We have finished up to question number 20 in regards to property law. And question number 21 is define a cell. What are the essentials of a valid cell? So, the very answer that we found regarding cell and its essentials of a valid cell under section 54 and section 54 itself describes about transfer of ownership, while section 53 provides about transfer of an intent. So, section 54 defines cell as follows: cell is transfer of ownership in exchange for a price paid or promised or part paid and part promised. The phrase transfer of ownership is significant as signifying that in a cell there is an absolute transfer of all the rights in the property sold. The expression transfer of ownership stands in contrast with the expression transfer of an interest as provided in section 53 in the definition of mortgage and with transfer of a right to enjoy property in the definition of lease. So, the very essentials elements of a cell, the elements of a cells are the parties, the subject matter, convenience, and price. So, regarding the first one, the parties to a cell are the seller, also called the vendor, and the buyer, called as vendee. So, while the seller is called vendor, the cell is called, or the buyer is called vendee. The seller must do competent to transfer, and the buyer may be any person who is not disqualified to be a transferee. So, in this regard, we would like to discuss an important leading case, that is Nuruddin versus Umaryathu Bibi in 1998. The Kerala High Court expressed that even a blind man can execute a cell deed when he is in a sound state of disposing mind, especially when he has understood the contents and the nature of the documents. So also in another important leading case, that is Srimati A. Bhagyama versus Bangalore Development Authority in 2010, Karnataka High Court held that the land was allotted by Bangalore Development Authority to one Abdul Alim by lease cum sale agreement. The allotee was put in possession by possession certificate. The allotee by power of attorney transferred the land to petitioner, who constructed a house on the basis of building plan approved by competent authority. The question was whether sale could be executed under power of attorney, which empowered to transfer, whether sale is permitted when transfer is permitted. the court held, yes, transfer includes power to sell, and the development authority would have to complete all formalities perfecting title to the petitioner. And now we'll go to the second essential element, that is subject matter. And regarding subject matter, there must be land and the benefits to arise out of the land, and also the things attached to the earth or falling under as subject matter. So the subject matter of a sale is immovable property. Immovable property includes the land, the benefits to arise out of land, and the things attached to earth. In other words, movable property includes both tangible movable property such as houses, land, and things attached to the earth, or intangible movable property such as benefits derived from land, for example, right of ferry or fishery, or a right to a mortgage debt. So, in that connection, we would like to discuss a leading case, that is Ramdas versus Sitawai. In 2009, Supreme Court held that an undivided share of co-sharer may be the subject matter of sale. That possession cannot be handed over to the vendee unless the property is partitioned by meets and bounds amicably and through mutual settlement, or by the degree of the court. And the third essential element is conveyance. And regarding conveyance, it is a kind of delivery of a tangible, immovable property. The sale does not become complete unless the seller actually does an act having an effect in law of transferring the seller's right in the property to the buyer. In case of tangible immovable property of the value of 100 rupees and upwards, or in case of intangible registered instrument, the transfer must be effected by a registered instrument. In the case of tangible immovable property of a value less than 100 rupees, the transfer may be made either by registered instrument or by delivery of the property. Delivery of a tangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. And the fourth essential element of a valid sale is price. So, price is otherwise called as the consideration of a sale. So, the consideration of a sale or price means money price if the consideration of the transfer is something other than money. It is not a sale. It may be an exchange, as it was held in the leading case, Commissioner of Income Tax versus Messrs. Motors and General Stores Private Limited in 1968 by the Supreme Court. So, but the prepayment of the price is not a condition precedent to the completion of the sale. If the intention is that the ownership should pass on registration of the sale deed. The sale is complete as soon as the deed is registered, whether the price has been paid or not, and the buyer can sue for the possession. This is clear from the words of the section. Price, fate, or promised, or part promised and part paid. The seller will, of course, have a charge on the property for the unpaid purchase money. A decree in favor of landlord on payment of compensation to tenant is not a sale as it was held by the Delhi High Court in the leading case Chhagan Lal versus Indian Iron and Steel Company Limited in 1979. So, in another important leading case, that is Lakshmi Narayan Barnwal, alias Lakshmi Narayan versus Jagdish Singh and another in 1991, Patna High Court expressed that the question as to whether upon execution of the deed of sale title passes to the vendee or not depends upon the intention of the parties. In terms of Section 54, read with Section 8 of the Transfer of Property Act, ordinarily the title of the vendor passes to the vendee on registration of the deed of sale, either in whole or in part. In fact, whether the consideration of money, either in whole or in part, has been paid by the vendee to the vendor or not, subject, of course, to a contrary intention of the parties to the said transaction. So, a registered deed of sale carries with it a sanctity of genuine transaction, and in this view of the matter, the burden of proof was hereby upon the plaintiff to show that despite the execution and registration of the said deed of sale, no title passed unto the defendant or vendee, as he did not pay the consideration amount to the original owner or vendor in view of the intention of the parties that unless consideration amount is paid, no title will pass unto the vendee, as it was decided in this important leading case by the Patna High Court in 1991, and the very case is Lakshmi Narayan Barnwal, alias Lakshmi Narayan versus Jagdish Singh and another in 1991. So, in our next upcoming video, we'll discuss question number 22, which asks enumerate the liabilities of the seller before and after completion of the sale.